Thank you for coming tonight. We're very excited to have the Attorney General's office here to discuss the open meeting law, an issue that we deal with daily and sometimes weekly, but we've got board members here, we have staff, we hopefully have some members of the public as well. This meeting is being taped on PTV and will appear on the town website as well. We're really hoping the public will tune in and find out what is expected of us as town hall employees and volunteers, so that they know what they can expect in agendas and the like. I'm looking forward to your questions to the Attorney General as well. We certainly have a lot of examples through the past years, and I'm looking forward to hearing the answers directly from the Attorney General's office. Hopefully you'll be asking them tonight. We're fortunate to have Mr. Sklarczyk and Mr. Higgins from the Attorney General's office here tonight to present the presentation. And really, thank you for coming tonight. I know it's a big deal. It's a Wednesday night. It's night. I'm glad you're here, and I'm really glad that you're here. Thank you very much.
Well, good evening. Thank you, everyone, for coming. My name is Jonathan Sklarczyk. I am an Assistant Attorney General with the Division of Open Government, and with me is Mark Higgins, who you may have met coming in. There he is. And it's also an Assistant Attorney General. I think we're keeping the door closed because I understand there's a practice going on upstairs that might cause a little bit of noise. So we'll try to do our best. I'll try to speak up. It's a good thing we're mic'd. So what we're going to talk about today is the open meeting law. We're going to talk about how to follow it, what's in the open meeting law, what you need to know as a board member, what you need to know as a member of the public, and we're going to take any questions you have. With a couple caveats. First of all, in order to keep this a nice, fluid presentation and to get you out in time for the Bruins game, we're going to hold all questions to the end. So we will certainly get through the presentation before the Bruins game, but we may still be in Q&A, so you can certainly feel free to leave at that time. But what we're going to do is there are index cards you should have had a chance to pick up on the way in, and if you still need some, there's more outside. If you have any questions on anything you hear during the presentation, write them down. And we're going to collect them halfway through the presentation, and then again at the end of the presentation, review them, and we'll go through all of your questions, and we will stay here until they're all answered. One thing that we can't talk about is if there's anything that has occurred. If it was something, that incident at a meeting last week, and you want to know, was that a violation of the open meeting law? We're not going to tell you whether something that has occurred was or was not a violation. What we're here to do is talk about what the rules are with respect to the open meeting law, how to follow it. We want to try to avoid specific scenarios and avoid any kind of conflicts with any boards. But we are really here to answer how the open meeting law works, and we're happy to take your questions. I'm going to cover the first half of the presentation, and Mark's going to cover the second half. We're going to talk about the open meeting law, the definitions about what bodies are subject to the open meeting law, what conduct by public bodies is subject to the open meeting law. We're going to talk about the notice and the requirements for notice. We're going to talk about public participation, remote participation. Mark's going to handle the second half, which is going to include executive sessions, the procedures for executive sessions, the purposes for executive session. He's going to talk about minutes and documents. And finally, the complaint process, where any individual can file a complaint alleging a violation of the open meeting law. So I'm going to get started. Adjust this a little bit. And I like to walk around a bit, but I've been told I have to stay still for the camera, so I'm going to be fidgety. I apologize. So the open meeting law, the purpose of the open meeting law is to recognize that balance between government accountability and government efficiency. And in the first part, it ensures transparency by requiring that the meetings of public bodies are noticed to the public, that the public has understanding as to when a meeting is going to occur and where, and that deliberations of the public body are open, with some exceptions we'll talk about in a moment, and that the public has access to those meetings. So that's the basic tenets of transparency. On the other end of that balance is allowing government to operate efficiently. So the law provides for certain activities to be conducted behind closed doors in executive session, and for certain documents to remain confidential for a period of time so that the government can conduct its business. Now, the Attorney General has a role with respect to the interpreting and enforcing the open meeting law. First off, we work very hard to educate and train members of the public and public bodies about the open meeting law. We conduct regional trainings across the state. We're actually now doing monthly webinars, which you can find out more information at our website, which, by the way, all the contact information and the resources are all on the last page of the presentation, so you have it all there. We have issued regulations that we involving how we enforce the open meeting law, some of our interpretations. We also provide direct guidance. If you have a question at any time, you can contact our division. We have a phone number, a hotline number, we have an email. Our website is a great resource. And again, all that contact information on the last slide. We also address open meeting law complaints, where any member of the public can file a complaint alleging that a public body has violated the open meeting law, and in response, we investigate those complaints and issue decisions and orders, and bring enforcement actions if necessary. So some quick basics, and I kind of went through this in the introduction, but notice must be posted for all meetings. If it's a meeting, it has to be noticed. Meetings must be open to the public unless the public body convenes an executive session. Although note, and Mark will talk about this, public bodies must always convene an open session first before voting to enter into executive session. Minutes must be kept for all meetings, open sessions and executive session. If it's a meeting, it has to be noticed and it has to have minutes. Public body members must also certify within 2 weeks of taking office that they have received the open meeting law, they've read it, and they understand the consequences for violating the open meeting law. And there's a certification form. We'll talk about that in a little bit. And finally, there's a complaint process. We're going to talk about that at the end of the presentation, where any person can file a complaint, forces the public body to respond to that complaint, and then the complainant can file with our office if they're not satisfied with the response. So I'm going to go right into the definitions in the open meeting law, and this comes right from the statute. And we're going to start with first, which entities are subject to the open meeting law? And the answer to that are public bodies. A public body is a multiple member board, commission, committee, or subcommittee, however created, elected, appointed, or otherwise constituted, established to serve a public purpose. And note that subcommittees are themselves public bodies and include any multiple member board created to advise or make recommendations to a public body. So if the Board of Selectmen creates a subcommittee to provide advice back to the Board of Selectmen, even if that subcommittee doesn't have any particular power or authority, even if they're just advisory, it's still a public body. Note, it's a multiple member board. So one individual is not a public body. The town administrator isn't in himself a public body, or the police chief. It has to be a multiple member board, 2 or more people. And it doesn't matter what it's called. It can be a board, a committee, a commission, a working group, a task force. The name doesn't really matter. What matters is that it's a multiple member board created and established to serve a public purpose. Now, there are some exclusions in the statute. The legislature is not a public body by exclusion in the statute. Bodies of the judicial branch, so juries, judicial panels, are not public bodies. Bodies created by a constitutional officer solely to advise the constitutional officer. Now, this only applies to the 6 state constitutional officers, so where the governor, lieutenant governor, treasurer, secretary, auditor, attorney general, when they create a group to advise just them on an issue they have sole authority over, that is not a public body. But that does not apply at the local level. Now, there are some bodies that don't serve a public purpose, and you'll see that, again, the requirement here is that it's established to serve a public purpose. I will say that 99% of the time, if this town or if the government is creating a body, it's probably serving a public purpose, but there's some examples where that doesn't hold true. One example might be where if the town creates a retirement party planning committee for a long-serving member, something like that really may be more of a private matter than a public one. But for the most part, when government creates a body, it's going to serve a public purpose. Finally, there are groups that are not established with the jurisdiction to make decisions or recommendations and to do so collectively. And so what we mean there is essentially a focus group. If the group that's being convened is not being convened to act collectively, to make a collective decision with a quorum and there's a specific membership, but rather we're bringing in 10 people and we're asking them to each give individual opinions, individual feedback. But as a group, it's really, there's no authority as a group or advisory authority as a group. That might not be a public body. It's a focus group. It's a little different. So those are some of the exclusions from the law. There's one additional important exclusion which is the Connolly exception. And this is a judicially created one from a Massachusetts Supreme Judicial Court case. And it says where a public official creates a group to advise that public official on a decision that he or she has sole responsibility for, the group is not subject to the open meeting law. So let me explain that one a little bit, and I'll use the example from that case. So that was a case where a superintendent was charged with hiring a principal for a school. And the superintendent decided, who could have gone out, interviewed 5 candidates, picked one, hired the candidate, end of story, decided to create a committee to advise the superintendent, interview candidates, make a recommendation back to the superintendent. I think that committee may have involved some parents, may have had school committee members, other stakeholders. And the court said because the superintendent could have made this decision without creating a committee, the fact that he created one doesn't make it a public body. So where a public official has sole authority to make a decision, the fact that they make a committee to help them make that decision does not make it a public body. But that only applies where it's a public official making that committee. If the school committee were to create a committee to advise it on hiring a superintendent, that would be a public body, because where a public body creates a committee to advise the public body, that's a public body. It's a subcommittee. So I hope that's clear, and if not, that's what the index cards are for. All right. So quickly, some examples. The Open Meeting Law Advisory Commission is an example of a state public body. And these distinctions, by the way, are going to matter in a couple slides when we talk about notice. But there are some public bodies that are created by statute, and that's where we see Open Meeting Law Advisory Commission, Board of Library Commissioners as an example. At the local level, you have your Board of Selectmen, Planning Board, Zoning Board are all local public bodies. At the regional level, regional school committees, Regional Water Commission. There's still county government. Certainly on Cape Cod, there's still county government in some places. So Board of County Commissioners, County Retirement Board, those are county public bodies, and that will matter for how notice is posted. Some examples of entities that are not public bodies. The State Senate, House of Representatives are not public bodies subject to the open meeting law. Judicial Nominating Commission, which advises the governor, is not. The Massachusetts Municipal Association is a private entity that advises boards of selectmen and advises municipalities, but it's not a government entity. It's not a public body. At the regional level, High School Boosters Club, that may be raising private funds to support public programs, is still a private entity. And at the local level, Neighborhood Watch, PTO, those are generally private organizations, and a Republican Democratic town committees, those are political groups which do not fall under the open meeting law. They sort of have their own set of rules and guidelines. So we talked a little bit about what entities are subject to the open meeting law, and that's public bodies. So the next question is, what conduct by the members of public bodies is covered under the open meeting law? And the most important definitions we're starting with is deliberation. Deliberation is an oral or written communication through any medium, including email, between or among a quorum of a public body on any business within its jurisdiction. So this is a very, very broad definition. And if there's anyone who recalls the older open meeting law, which was reformed, by the way, in 2010, is when this definition changed and a lot of the parts of the law changed. It used to be a more narrow definition, but it's now pretty broad. Any communication between or among a quorum on any business within the jurisdiction of the board is going to be deliberation. Now, a quorum is generally going to be a majority. It depends whether there is some other statute that sets it otherwise, but most of the time it's a majority. So if you have a 7-member board, if 4 members are going to talk to each other about anything within the body's jurisdiction, that's a deliberation, whether it's email, whether it's in person, whether it's over the phone. Now, the one thing to be cognizant of is serial communications. If, let's say you have a 5-person board, and person A calls person B, and person B then calls person C and says, hey, I just spoke to person A about this topic, even though they didn't all speak at the same time, 3 people out of 5 talked about a topic. That's deliberation. It's a serial communication. So you have to be very careful. And this becomes a real problem with email because you don't always know when you send an email to somebody who they're going to forward it to. So you do want to be very, very careful with in how you treat deliberation. Now, there are some exclusions. Distribution of a meeting agenda, for example. The chair can send out an email saying, here is the agenda for next week's meeting. That's fine, not a deliberation. Or scheduling or procedural information. So if the chair wants to email the board and say, we need to schedule our next meeting, here are the dates I propose, or here are the locations, those discussions are not considered deliberation. Now, also, distribution of reports or documents to be discussed, provided, however, that no opinion of a member of the public body is expressed. So it's okay for the chair to send out an email saying, here are the documents I would like you to review for the meeting. These are the documents we will be discussing at the meeting. It's not okay, or any board member can say, here's a document I'd like us to discuss at the meeting. It's not okay to say, here's a report I'd like us to discuss at the meeting, and I think we should vote to adopt it, or I think we should vote not to adopt it. You want to be a little careful here. Sometimes somebody said, like the document that somebody's sharing is just basically their opinions. So you want to avoid that as much as possible, and they really should be informational documents or documents that the board is considering in the course of its business, and leave the expression of opinion about business within the board's jurisdiction to the meeting itself. Because ultimately, this is about transparency, and it's about the public being able to witness what the board is looking at when they're looking at it as a group. One thing to keep in mind is that if it's a subquorum, that's okay. It's not a deliberation. So if you have a 7-member board and 3 members, 4 is a quorum, if 3 members meet in a coffee shop and talk about business, that's not a deliberation. That may have an appearance, and some people might be upset, but that's entirely up to those members of the public body. As soon as a 4th person joins the discussion, that's a deliberation. The next important definition is meeting. And meeting says that it's a deliberation by a public body with respect to any matter within the body's jurisdiction. So really what we're saying here is that when a public body deliberates, it has to do so at a meeting. When it's deliberating, that's a meeting. Now, there are some exclusions. An on-site inspection provided no deliberation. So a board could go to meet at a location to review a site, to review a building project or a park. But the members, if there's a quorum present, cannot deliberate. There cannot be any communication between or among that quorum on any matters within their jurisdiction. So this makes it very, very difficult. So either you have to post a notice and have a meeting at that site, or you have to have a quorum present and really not talk and just listen, or you would want to make sure that fewer than a quorum attend. So that's a tough one to navigate sometimes. Attendance by a quorum at an event provided no deliberation. And we get this question a lot saying, well, can we all go to the annual town holiday party or this event? If 4 out of 5 selectmen are present, is that okay? Sure. You can always be at an event so long as there's no deliberation between or among a quorum. So that's really what you need to think about. Attendance by a quorum at a meeting of another public body provided no deliberation. So if the school committee wishes to attend the Board of Selectmen meeting, they can do that provided there's no deliberation. So if the Board of Selectmen were sitting up here and the school committee members were in the audience, and maybe they got up to speak when recognized as individuals, that's fine, so long as they're not communicating back and forth with each other. If the school committee wants to present as a committee and as a quorum to the board, then they would need to post a joint notice for a joint meeting. Meetings of a quasi-judicial board for the sole purpose of making a decision in an adjudicatory proceeding. That's excluded. This, fortunately, only applies to state public bodies. There are certain state quasi-judicial boards, for example, boards that review a doctor's license, or other boards that are making adjudicatory decisions. And this exception says that in the part where they're making their decision, essentially where the jury is out and they're considering whether or not to censure a license or some decision of that nature, that's not a meeting. But that does not apply to any local public bodies. And finally, town meeting is not subject to the open meeting law. A town meeting is not a meeting, and any public body's meeting during town meeting, that's not covered under the open meeting law. I will note that is an interpretation. It's a little bit gray in the law, and that's an interpretation of this Attorney General. So the next Attorney General could interpret it a little differently with respect to what public bodies conduct during town meetings is subject to the open meeting law. Town meeting itself, definitely not subject to the open meeting law. We've interpreted that public bodies may meet during open meeting law, may be called upon during town meeting, may be called upon during town meeting. They don't have to follow the requirements of the open meeting law because they're in a big public town meeting. So we talked a little bit about the important definitions. We talked about public body, the conduct, deliberation meeting. So the next piece to know is notice. And anytime there's a deliberation, there has to be a meeting. Anytime there's a meeting, there needs to be notice to inform the public about that meeting. Now, except in an emergency, a public body must post notice of a meeting at least 48 hours in advance, excluding Saturdays, Sundays, and legal holidays. So this requires a little bit of math. It's not hard math, except for holidays, which always throw me off. But so if there's a meeting on a Monday, then the notice has to be noticed. The meeting has to be noticed and posted by the previous Thursday. So if you're posting on Friday, then that's for a Tuesday meeting. Of course, if Monday's a holiday, then that throws everything off a day. So things to keep in mind. Notice must include the date of the meeting, the time of the meeting, the place of the meeting, and if you can, specify what room, because sometimes the meeting just says town hall and people are walking around back and forth and don't know where it is. And most importantly, and this is where we get a lot of our open meeting law complaints, so pay attention to this one, the notice must include a list of the topics the chair reasonably anticipates will be discussed at the meeting. And the topic should give enough specificity so that the public will understand what will be discussed. So everything that the chair reasonably anticipates occurring during the meeting, any topics for discussion, really should be listed in detail. And if you're the one writing the meeting notice, you should sort of approach it as, if I was a member of the public, what information would I need to know to be able to decide whether or not it's in my interest to attend this meeting? Really, well, I've seen some terrible notices that just say, convene, new business, old business, adjourn, right? That tells you nothing. You can certainly have old business and new business as categories, but there really needs to be some detail in the topics that say what it is we're going to talk about. And finally, on the notice itself should be a date stamp or something with the notice that says what time and date it was posted, so that the public knows that it was, in fact, posted 48 hours in advance and that it's a timely posted notice. All right, I feel like I have theme music now. This is great. So one of the exceptions with the 48 hours is an emergency. So, or really the only exception. An emergency is a sudden, generally unexpected occurrence or set of circumstances demanding immediate action. And in an emergency, the public body only needs to post notice as soon as reasonably possible. They don't have to wait 48 hours because it's an emergency. Now, emergency is pretty narrowly applied. It really has to be something unexpected. This wasn't because a deadline came up and we just haven't been able to meet it yet, and so now we have to meet tonight. It can't be something where it was well known in advance. It has to be really unexpected, and it has to demand immediate action. The body cannot wait 48 hours. It might be a threat to public health or safety. An example is a water main break or some other public safety issue where the board needs to meet right away to authorize funds or for some other reason. It really should not be, and we've gotten a lot of complaints where boards use emergency rather loosely. So you want to be careful there. An example might be the members realize that they're all going to be on vacation for the next 2 weeks, and unless they meet tonight, they're not going to be able to meet for another 3 weeks, and that was unexpected, and that demands that we meet tonight. That's not going to fly. It really does have to require some immediate action and be an important public reason. If you ever have questions, obviously with any of this, but particularly in something like emergency, you can always contact our office, contact town council, but certainly feel free to contact our office and we'd be happy to advise you. All right. So meeting notices for local public bodies. Local public bodies must file a notice with the municipal clerk, and the notice must be posted in a manner conspicuously visible to the public, including persons with disabilities, at all hours in or on the municipal building where the clerk's office is located. So this requires that the notice be available 24/7. Some town halls, they have the notices on bulletin boards right outside or in a vestibule. There are, however, alternative notice posting locations that the Attorney General has authorized through our regulations. The most common one is the municipal website. There's a couple others that you can see. If you have questions, I'm happy to answer about those. But the main alternative is the website. So if the town decides to adopt the website as its alternative, the town can notify our office and say, we've adopted this, the website. And then from that point on, the website is where the official notice posting occurs. The clerk's office still needs to keep a physical copy available not 24/7, but during regular business hours for any person wishing to see a meeting notice. But as long as it's on the web 24/7, then that will comply. Now, with regional or district public bodies, it has to be within each city or town within the region in the manner prescribed for that local public body, or post to a website. Again, if the regional public body chooses, they can notify our office. And it's often, if you're a regional public body and you have 15 towns in your region, just one town doesn't post and your meeting is invalid. So it's a good idea to consider the alternatives of a website there. Regional school district, it's the secretary of the regional school is the clerk, and they have to file notice with the clerk in each city or town. And county public bodies has to be filed in the filed with the Office of the County Commissioners, and a copy posted in a manner conspicuously visible to the public at all hours of the County Commissioner's designation, but also they can choose a website. And again, that seems to be where a lot of public bodies and towns tend to go. All right. So meeting notices for state public bodies are a little different. For a state public body, they need to post to the state public body's website or the website of its parent agency. So they're actually required by law to post to a website. And the state public body needs to notify our office of its location of the website. And they also have to send a copy of every notice to the Secretary of State's office to this address right here. They do not need to send a copy. Nobody needs to send a copy of their notices to us. We get plenty of mail as it is. So please don't send us your meeting notices. All right. Some common concerns that come up with notice posting. So maybe this will prevent a couple index cards right off the bat. So what if a new topic arises after the notice is posted? So public bodies are encouraged to update the meeting notice. If a topic arises within the 48 hours and it wasn't listed in the meeting notice, the public body can still consider it and discuss it during its meeting if it was not reasonably anticipated by the chair 48 hours before the meeting. That's the real line. Is it reasonably anticipated by the chair 48 hours? If it was, and the chair left it off the notice, it cannot be discussed. If it was not reasonably anticipated by the chair, then the public body may choose to discuss it. They can vote, they can take action. We encourage public bodies to first update their meeting notice if they plan to add a topic that was unanticipated. But additionally, we encourage public bodies to consider postponing discussion or any action on items that were not included in a notice, particularly ones that are of great public interest or maybe a large vote or significant vote, large expenditure. Anything of that nature, it's probably a good idea, if you can, to postpone, put it in a meeting notice so that the public can see at the next meeting and have the opportunity to come to the meeting. But it's up to the public body. It's not a violation of the open meeting law. So an unanticipated topic may be discussed at a meeting. Now, chairs really should not post notices so far in advance that there's this high likelihood that topics will arise. I've seen some public bodies which say, here's our 4 agenda topics, and here are the next 6 months that we're meeting. And that's it. And it really, it's certainly fine to post a calendar of when you expect to meet over the course of the year, but the notice should be close enough to the meeting so that there's a really likelihood that these are the topics that the public body will be discussing. Now, what if the clerk can't post the notice in time? This happens. I get phone calls all the time where somebody posted the meeting notice 50 hours before the meeting, but the clerk didn't get it up till 46 hours before the meeting. Can we still go ahead? The answer is no. It requires strictly that the public has 48 hours notice. And although the clerk is the one who is going to post it, it's incumbent upon the public bodies to make sure you work with the clerks, you know the clerk's hours, and that you really don't get it in at 48 hours and 5 minutes. Try to give the clerk time to get it posted, because ultimately, if it does not get posted, it may not be your fault as the chair of a public body, but if the meeting wasn't posted, you cannot hold the meeting. Now, canceling a meeting. Meeting cancellations do not require 48 hours You can cancel a meeting anytime. It's just a good idea to maybe put a notice wherever the meeting notice was saying this meeting has been canceled. You might want to put a notice at the door at the room where that meeting was supposed to be held. But keep in mind that if you're going to reschedule that meeting, you have to post a new notice 48 hours in advance. You can't just say, this meeting's canceled, we're going to meet tomorrow night instead. You have to have 48 hours notice. Additionally, if you are going to hold a meeting and if you have a meeting and it's running late and you want to continue that meeting to a later date, you still have to post 48 hours. So if the meeting is going really to past 11 on a Tuesday, you can't say we're going to reconvene tomorrow night. You have to post a new notice 48 hours. One, if you anticipate multiple nights of meetings, you can post for multiple nights. So you could post a notice that says Tuesday night, Wednesday night meeting, and if you finish everything on Tuesday, you could cancel the Wednesday meeting. So that's one way to think about it to ensure that you've given the public adequate notice of when you're meeting. And keep in mind about other laws that sometimes apply in terms of notice. The open meeting law notice is the 48-hour notice I talked about, but there are other laws such as for public hearings. There may be a public hearing taking place during a meeting that requires 2 weeks' notice in a newspaper. Those are under separate laws, so you want to be aware of those laws as well. Quick note about accessibility. So public bodies must abide by all applicable state and federal laws that govern accessibility for the disabled. It's really important to make sure that your meeting locations are accessible to all members of the public and that you can make any necessary accommodations for anybody who has any needs. And you want to make sure that you meet in a handicap accessible location. It does not, by the way, have to be a public location. You don't have to necessarily meet in a town hall or a town-owned building. It could be a residence. It could be a restaurant. But it has to be accessible to members of the public. So if you have any questions about accessibility, you can feel free to contact our office, and our Civil Rights Division has a Disability Rights Project that's also available to guide municipalities on making sure their meetings are accessible to everybody. I'm going to talk a little bit about remote participation, and this comes from our regulations. So we had to sort of come up with this program after the statute sort of said we leave it to the Attorney General. So this is what we came up with. Remote participation, which we're talking about calling into a meeting, if you're a board member, this only applies to members of the public body, not members of the public generally. So if members of the public body wish to participate remotely, it first has to be adopted by, in the case of local public bodies, the chief executive officer. So in that case, that's usually the Board of Selectmen, and in the cities, it's often the mayor. For county public bodies, it would be the county commissioners, and for all other public bodies, it's a majority vote. So they have to say, they have to take a vote that says, from here on out, we are adopting remote participation for our members to use. And that would apply to all the public bodies within its jurisdiction. So if it's the Board of Selectmen, that would apply to all the public bodies within the community. There are minimum requirements when using remote participation. First, remote participants and all persons present at the meeting location must be clearly audible to each other. So if there's, for example, by teleconference, there's a speakerphone in the front, it's got to be loud enough so that all members in the room can hear it, not just the people sitting at front. Quorum of the public body, including the chair, or in the chair's absence, the person chairing the meeting, must be physically present at the meeting location. So there has to be a quorum physically in the room. If it's a 5-member board, 3 people have to be physically present if 2 are calling in. There can't be 3 calling in and 2 present. And whoever is chairing the meeting has to be in the room and physically present. They can't chair over the phone. So if the chair is participating, they have to hand off the chairing duty to somebody else. And members of public bodies who participate remotely do have the right to vote. They're not deemed absent or non-participating members. If they're participating remotely and they follow these requirements, then they are full voting members. Now, there are only 5 permissible reasons for remote participation, and 1 or more of these reasons must make physical attendance unreasonably difficult. And the thing to take away from here is that remote participation there should be a reason for remote participation. It shouldn't be a matter of mere convenience and not wanting to attend. The Attorney General does believe that there's great value in having a physical meeting and having members of the public be able to view all of the members of a public body as they're deliberating. But where any of these 5, whether it's personal illness, personal disability, an emergency, military service, or geographic distance. Where any of these makes physical attendance unreasonably difficult, then that member may participate remotely. Now, we did not define these very specifically. We left them pretty broad. And we leave it up to the public body and the chair to determine how they want to interpret emergency or geographic distance. Is going to Florida geographic distance that makes it unreasonably difficult? Probably. Is being at a meeting at the other end of town? We leave that up to the public bodies to decide. Now, procedures for remote participation. If a member knows that they cannot participate physically in a meeting and wishes to call in or participate remotely, assuming it's been adopted, first they have to notify the chair. During the meeting, the chair will make an announcement at the beginning and publicly state who is participating remotely. All votes that happen in a meeting where there's a participant who's participating remotely have to be roll call votes. A roll call vote is where they call all the members of the board and they say yes, no, abstain, and that's recorded that way in the minutes. It also needs to be recorded in the minutes who's participating remotely. During executive sessions, members who are participating remotely need to inform the chair that they are in a secure location, that there's nobody else there in the room with them who can hear the executive session unless that other individual has been approved by the board. And that declaration needs to be recorded in the minutes. And finally, the chair needs to make every possible effort to distribute or get documents that are distributed in a meeting to the remote participant, whether it's email, scanning, and whatever they can do. They just need to make their best effort. Now, there's a number of acceptable methods for remote participation. Telephone, internet, satellite-enabled audio or video conferencing are all acceptable. Any technology that's going to enable remote participants and all persons in the room present at the meeting location to be clearly audible to one another. That's really the requirement, that everybody can hear. The audience can hear the remote participant can hear the audience and the board members. And we leave it up to the public bodies to determine which method to use. However, if using video technology, it's important that the person participating by video be seen by the audience. You don't want to set up a screen that's just facing the board and that the audience can't see the person. And finally, technical difficulties, almost guaranteed they're going to come up. Happens all the time with remote participation. So we leave it up to the chair to decide how to handle problems that come up or technical difficulties. So for example, if the call gets lost, then the chair can decide to pause the meeting, try to get the person back on the phone. They can decide to continue with the meeting, but whatever they decide, they should make a note of it in the minutes. All right, public participation. Now, any member of the public may attend an open session of a meeting of a public body. However, the public does not have the right to address the meeting without the permission of the chair. The chair has the authority to decide who can and cannot speak, and the chair can decide not to allow public comment, to allow public comment. It's up to the chair. Certainly, we encourage all public bodies to leave some time for public comment if time permits. Now, the public does have a right to make an audio or video recording of an open session as long as they've notified the chair, and the chair is then announced to the public that the meeting is being recorded. And finally, the chair does have the authority to really keep control of the meeting and to run the meeting. So if an individual is being disruptive, the chair can issue that individual a warning. And if the person continues to be disruptive, the chair can ask that individual to leave. And if the person does not leave, then the chair can have a police officer remove that individual. So hopefully the meetings don't come to that too often, but that power does, by law, reside with the chair. So I'm actually going to hand this over to Mark to finish with the next part of the presentation. What I'll do now is, if you have any questions about that first half of the topics I went through, I will collect them and take a look at them, and I'll start off our Q&A addressing those questions. So I'm going to come around now and collect them, and hold on some cards if you have maybe more questions coming up.
Thank you, Jonathan. Good evening, and my name is Mark Higgins, and I will be doing executive sessions, meeting records, and the complaint process, along with a couple other flotsam and jetsam parts of the open meeting law. Executive sessions are confidential closed sessions of public bodies. While the open meeting law emphasizes government transparency, it does recognize that certain situations are best conducted behind closed doors. However, there are a very narrow set of circumstances in which that is appropriate, and those are clearly defined in the law. A public body, when doing the public's business, may not exclude the public from its deliberations unless it falls under these 10 exceptions that are defined in the law. The procedure for entering into executive session is the same no matter what reason you're entering executive session. I'm going to say executive session about 5 times, and it's going to start sounding weird in my head as I say it, so if I go off, just somebody tell me. First of all, you must notice that you're going to open in open session. So you don't just open a meeting in executive session. You have to stand up here and say, all right, this is an open session meeting, even though the only thing we're doing is going to executive session. You open an executive session, you say, do I have a motion to enter into executive session? Someone says, yes. All right, why are we going into executive session? You have to state the purpose. The reason you have to state the purpose, and you also must state the purpose on your agenda, is that the statements before the public body enters executive session is the only information the public has on whether the executive session is proper or improper. And if it's improper, it's illegal. It's in violation of the law. So this is a very important moment for the public body. If they do this right, they can have an executive session. So once they have announced their reason, they conduct a roll call vote to enter executive session. And then they also, before going into executive session, announce whether they'll reconvene an open session. This is for a very practical reason. Does the public know whether to stick around or not when they go in? If they're only meeting executive session that night, everyone go home. You won't see us when we close the meeting. But if they're coming back into open session and doing deliberations, you guys might want to stick around and watch what we do afterwards. If there are remote participants during the meeting, the remote participants must state that they are able to hear the discussion at the remote location, and additionally, that no one else is with them that is able to hear the discussion or deliberations unless the public body wants that additional person to be there, which makes sense. Otherwise, you lose the confidentiality of the executive session. While a public body is in executive session, they have to maintain minutes and records just as if they were in open session. And that's something I'll go over in a little bit. While they're in executive session, the chair must make sure that the discussions which occur during the executive session remain on topic. If you stray or deliberations sort of start going off someplace where they're not supposed to, the chair must control that, or those deliberations must occur in open session. These reasons for going into executive session are very narrow, and they must be maintained in order to keep the confidentiality of the session. And any votes taken during executive session are roll call. Again, for reasons when confidentiality is involved, you want to know who voted for what. So these are the 10 purposes a public body may enter into executive session, and I'll go through these one by one. I'll read the statutory reasons every time just because the language is gorgeous. To discuss the reputation, character, physical condition, or mental health rather than the professional competence of an individual, or to discuss the discipline or dismissal of or complaints or charges brought against a public officer, employee, staff member, or individual. So the way I'll reference this executive session purpose and the remaining ones is by their number. So this is purpose 1. Purpose 1 is about the privacy of the individual being discussed. You'll notice that this whole policy behind this is if we're going to talk about someone's reputation, character, whether we think they've done something wrong, you don't necessarily need to make that public business right away. And this is an appropriate time to use an executive session. However, when you're going to discuss an individual under this executive session, that individual has some rights. The first of which is they are notified in writing 48 hours in advance that this executive session will occur and they will be the subject of deliberation. Second, the individual says, no, I don't want you guys to protect my privacy. I want this discussion in open session. They have the right to request open session for the meeting. And this is, again, makes sense. It's the privacy of the individual which is being protected. It's not the public body's right to discuss an individual in private. The individual has the right to be present during the executive session deliberations for all parts of that deliberation which concern them. They have the right to have counsel or a representative present for the purpose of advising them, but that additional person in the room does not have the right to speak on the individual or the subject's behalf. So you can have someone whispering in your ear, but that person doesn't get to address the public body unless allowed by the public body. But the individual or the subject of the executive session does have the right to address the public body during the deliberations. And finally, the individual has the right to cause an independent record to be made, either by recording or transcription. And this is so that the individual is not relying on the records of the public body, which can be a contentious moment sometimes. So that's executive session purpose number 1. Purpose number 2 is to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. So this is your non-union personnel negotiation exception. If you are hiring a town manager, police chief, this is the part where you've selected the finalists for the job and now you want to talk numbers and what the contract's going to look like. So when you're discussing the contract of any non-union personnel, the presumption is that you've already discussed why they're good for the job. Now you're talking about other aspects of the job. This executive session purpose should not be used to conduct a review of job performance. And also, neither should purpose 1. You may remember that it says right here, rather than professional competence. Professional competence is a subject which should be always discussed in open session unless it directly relates to contract negotiations. It should not, this executive session purpose is not a vehicle for performing an annual review. When you are negotiating a non-union contract and you reach final terms, the execution of that contract occurs in open session, which is a difference you'll find from the next slide. The vote must occur in open session. You can't vote on a non-union contract in executive session. But in purpose number 3, which is our collective bargaining session, executive session purpose, you may approve the final terms and execute a collective bargaining agreement in that executive session, although it's always a good idea when doing that to disclose that to the public shortly thereafter. Now, executive session purpose number 3 is to discuss strategy with respect to collective bargaining or litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. So this is where we start seeing some statutory language, beyond the fact that this is about collective bargaining and litigation, but that this executive session purpose is not available to the public body unless having that discussion in open session would be bad for the public body. If we can save ourselves money, if we can have a better negotiating position by having this conversation privately instead of out in the open, then you can go into executive session. But if nothing would change whether the public witnessed that discussion or not, or say the party on the other side of the table witnessed that discussion or not, then this executive session purpose would be inappropriate. If this is about litigation, so you can also use this when you are the subject of a lawsuit or you're considering filing a lawsuit, the litigation must be pending or imminently threatened. So pending or imminently threatened is a demand letter upon the town. You know that there's been a filing in Superior Court or District Court or whatever the appropriate forum is. It is not the guy last night who walked out of the town meeting and said, "I'm going to sue the whole lot of you." That is not imminently threatened litigation, okay? We know the difference. You know the difference. Don't play with it. The next 2 purposes for executive session are fairly self-explanatory, so I'm not actually going to give them individual slides. Purpose number 4 is for the deployment of security personnel or devices. This is for a very simple reason. Public safety doesn't have to be given away to the bad guys. If you want to talk about where cops are going to be on a parade route, you want to talk about responses to different disaster scenarios, fine. Do it in an executive session. We're okay with it. Whether you should or not, or is a political decision, but in terms of if it involves the deployment of security or in any other way, the law allows you to have that conversation confidentially. Purpose number 5 is for the consideration of criminal misconduct charges. This is, the public body has discovered that a town employee is embezzling funds, or we think they are, and we wish to discuss whether we're going to recommend charges to the local district attorney for misuse of public funds. This would be an appropriate executive session purpose. It's pretty self-explanatory at that point. Purpose number 6, though, is to consider the purchase, exchange, lease, or value of real property if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. There's that language again. If having this conversation about the purchase, sale, lease, or value of real property in public would somehow detrimentally affect the negotiating position of the public body, they don't have to have that conversation in the open. They can use this executive session purpose. So if you're considering buying something and you know that telling the potential seller that you were considering buying it would raise the price, you don't have to let the public know. And I'll tell you, at some point you do, but not right now. But if it's, what color are we going to paint all town buildings, that might affect the value of real property, but that's not really something that should be conducted in, closed session. So again, this is a judgment call, and the chair must declare that it would have a detrimental effect on their negotiating position. Purpose number 7 is a bit of a catch-all because it employs the use of other statutes. This is to comply with or act under the authority of any general or special law or federal grant and aid requirements. When you're using this executive session purpose, when you say the body is now about to go into executive session under purpose number 7 to comply with some general or special law or federal grant and aid requirement, the statute that is requiring us to be confidential or to conduct this in closed session is, and then you will cite the statute. A good example of this is tax records. Tax records in the Commonwealth of Massachusetts are by statute confidential records. So a Board of Assessors reviewing a request for abatement can be in closed session because the tax records they would be reviewing are confidential as well. Executive session purpose number 8 is my least favorite executive session to explain to people. This is to consider or interview applicants for employment or appointment by preliminary screening committee if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants, provided, however, that this clause shall not apply to any meeting, including meetings of a preliminary screening committee, to consider and interview applicants who have passed a prior preliminary screening. So it's very clear, and we'll just move on from there. Let's break this down a little bit. First, if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants, there's a job opening, either in town or on a board, and you are asking for applicants. If we ask for these applicants to come do their initial interviews in open session, somebody that we want might not come. So you can do initial interviews in closed session if you determine that your pool of applicants would be larger than if you did it in open session. Second, however, this clause should not apply to any meeting, including meetings of that preliminary screening committee, to consider and interview applicants who have passed a prior preliminary screening. You cannot meet in executive session if you have established finalists. Final round interviews must be done in open session. And the decision can't be made in executive session. So, moving on from there, the preliminary screening committee that the law envisions, thank you. I don't know why I had a problem with that. Envisions here is the Board of Selectmen are saying we want to consider hiring somebody. We're going to create a search committee. First of all, if any members of the Select Board wish to participate in that screening committee, it cannot be a quorum of the Select Board. It cannot be a quorum of the parent body. It doesn't have to be any members of the parent body, but if there are members of the parent body, there cannot be a quorum of there on there. And this is because they do not want the decision to be made before the finalists appear in open session before the parent body. And then may include any other member of the public that they wish. As I've mentioned, only the preliminary interview can be done in executive session. Once the committee has arrived at final lists, not one, but multiple, those final interviews must be conducted in open session. There is one situation in which a preliminary screening committee can have a final list instead of final lists, and that is if they do not have enough qualified applicants. A qualified applicant is someone who is objectively qualified. So if you have 5 applicants for a position, and the position requires a master's, the listing says must have a master's degree, and 4 of them only have bachelor's and 1 has a master's, then you can report the single final list for fulfilling the objective requirements of the position. It's not we didn't like them, it's that they do not fit the minimum stated objective requirements of this position. That is the difference between a qualified and unqualified applicant. and that is the only time you may report a final list as opposed to final lists. And again, as I stated, the chair should declare that doing any of this in executive session would have a detrimental effect on the body's work. The last two are similarly sort of straightforward. A body may meet in executive session to confer with a mediator on litigation or any other decision which involves mediation. This is again to promote candor and settlement. It's essentially an offshoot of the executive session purpose number 3, which involves litigation. And 10, I doubt applies. I don't think there's a municipal light company this far out on the Cape, but if there is, if you are a public body engaged as an energy supplier, if you are discussing trade secrets in the course of your activities as an energy supplier, then you may meet in executive session. But there's, I guess there is one, but sorry. There's only like 40 in the whole Commonwealth, and I always forget where they are. And so, before we move on from executive session, I would just stress one thing. I would stress under Purpose 3, which is litigation or collective bargaining, under Purpose 6, which is the acquisition of real property, and under Purpose 8, that the chair must declare before they go into executive session that if they didn't go into executive session, the negotiating position of the public body would be detrimentally affected. Otherwise, those purposes are not available. Okay. Now we know whether we're meeting in open or executive. We know why we're meeting in executive. What do we do next? Well, now we have to keep records of what we're doing. So we're going to take minutes. And no matter whether it's executive session or open session, those minutes must state the date, time, place of the meeting, and a list of members present or absent. It must also include a summary of discussion of each topic. This summary, people say, well, how much information is there supposed to be? We don't think this is a good summary. It's very difficult to tell you exactly how much detail to put into minutes. Basically, if there's 3 viewpoints in the room, the minutes should reflect the deliberation over 3 viewpoints. If it's something everyone agrees with, it probably doesn't need to be that extensive of a topic. Use your judgment. People complain about this all the time. It's very difficult for us to pass judgment on it. The minutes must also describe any decisions made and actions taken, including a record of all votes. However, I would remind you that in the Commonwealth of Massachusetts, there are no secret ballots. And the minutes must also have a list of documents and other exhibits used by the body at the meeting, including by remote participants. So if you are viewing a whole plethora of exhibits, the minutes must state each exhibit and just a list at the bottom. The minutes do not themselves need to include the exhibits. And we'll talk about what to do with any documents or exhibits used in a meeting in a little bit. And if someone participates remotely, the minutes should reflect that and the reason why they participated remotely. So, now that you know what's supposed to be in minutes, what do you do with them? You are supposed to create and approve them in a timely manner for both open and executive sessions. A timely manner is not defined in the law, but our office encourages and interprets a timely manner as the next meeting. So you have a meeting, you take the minutes in draft form, you write them up, and you approve them at the next meeting. We have seen bodies that have not approved minutes since 1986. Don't be that body. We don't like that body. If you have a document or an exhibit used by the public body, that must be retained. So if you view documents or exhibits from somebody, you have to retain those documents and exhibits. Those are now public records. But you do not need to physically store them with the meeting minutes. So someone requests the meeting minutes, you give them over, but it just includes the list of documents. It doesn't need to include, the mock-up of the house and all that sort of stuff. They can request that separately. And for how long you're supposed to hold on to those, I would refer you to the Secretary of State's Public Records Retention Schedule. That is available on the Public Records Division website, and you can also call them up. They're very nice people, just like we are. If a person requests minutes of an open session, you have to give them up within 10 days, whether they're approved or draft form. No questions. 10 days, give them up. If they are executive session records that are being requested, there's a little bit of a finer, different process there. But the rule that when you're reviewing executive session records, and we'll go into this in a little bit more detail in a second, is that if there was a reason you were confidential to begin with, and that reason that you conducted a confidential session continues, you still do not need to disclose them. But once the reason you were confidential in the first place is no longer important, then they become essentially open records and you have to disclose them. And that's what we're going to talk about right now. So executive session minutes, because they're not available to the public right away and they're not posted publicly, must be reviewed periodically to ensure that they're still relevant to the purpose which was cited to keep them confidential. That determination should be conducted regularly, whether every meeting, quarterly, pick a schedule, stick to it. When you make a decision, every time you make a determination, yes, we were going to keep these confidential, but we're going to release these, announce it in your minutes. And this is so the public, when they're working backwards through the minutes of the public body, can track what has been and has not been released. This is, I mean, if you think of this as if someone came from the future and wanted to find out what you were doing, that they could figure it out and they wouldn't have to be there to know what happened. The public body, if they receive a request for executive session minutes, just like if they receive a request for open session minutes, must respond in 10 days. But there is a different kind of response that they're going to give. Either they've already determined that those executive session minutes are no longer exempt from disclosure, and therefore they're essentially, for all intents and purposes, open session minutes. You give them up within 10 days, just like you do with open session minutes. 10 days, give them up, no matter what form they're in. However, if you think that they should be kept confidential, the public body must undertake a review at its next meeting or within 30 days, whichever is sooner. And at that review, two things will occur. Either they'll say, yes, these should continue to be kept confidential, or no, these should be released. If they should be released, you give them up. If you think they should be kept confidential, you write a letter saying we still think these should be kept confidential, and you give it to the person requesting executive session minutes. Right? Good. I'm seeing some nods. All right. No matter what, whether it's open session, this won't occur in open session, but in an executive session, some documents, no matter what happens, are always going to be exempt from disclosure. The easiest way to think about this is employment records are exempt from disclosure. Specifically, materials used in performance evaluation of an individual bearing on his or her professional competence that were not created by members of the body for purposes of evaluation. If part of a superintendent's evaluation is a teacher's evaluation from the high school, the teacher's evaluations are confidential because they're not members of the public body. However, if also part of a superintendent's evaluation are members of the school committee's individual evaluations, those must be publicly disclosed. That's the difference. Who wrote them? Either the teachers or the people on the school committee. Any materials used in deliberations about employment or appointment of individuals, including applications and supporting materials, but excluding resumes, which must be disclosed. So basically, anything that comes in during an application process is confidential except for the resumes. Resumes are a public record which can be disclosed. Who did you consider? Where did they go? What kind of people were they? So, now that we know what is required of you, what do you do once you're elected, appointed, or whatever it is they do to people when they get put on a board? They receive materials, the open meeting law guide from our office, copy of the regulations, and a copy of the statute itself, which is scintillating reading. And the person giving you this, if you're a local public body, should be your clerk. If you're any other level, state, district, regional, it should be the executive director, the person in charge of the paperwork, should be giving you all these materials as well as a certification form, which you will sign within 2 weeks of receiving it. And when you sign it, you will say that you understand everything about the open meeting law. You will always follow it, and you can't believe that people even think of violating it. And so when you sign that certification, you give it back to the person who gave it to you, and they keep it. It's a public record. The public has a right to go in and say, hey, he knows what the open meeting law is. Now, you have certified that you understand the open meeting law. You know what the open meeting law requires. However, a member of the public has decided that, no, you do not know what the public, you do not know what the open meeting law is, and in fact, you have violated it. What happens? Well, that member of the public will file with the public body, the chair of the public body, an open meeting law complaint form. It is an official form. It is available on our website. It should also be available in the clerk's office, and it's standardized. It must be signed. There are no anonymous open meeting law complaints. We will not review them, neither does the public body. That complaint must be filed within 30 days of the alleged violation. Or, if it's a secret violation, They must be filed within 30 days of when the person should have discovered it. So if you have any questions about when someone should have discovered something, sometimes it's a matter of judgment, but if it happened in open session, normally that's when the clock starts. 30 days from that moment is when you have to file your initial complaint. So now the chair has received the open meeting law complaint form. What do? They do not put it in a drawer. They do not write a single letter. The thing that they do is they copy it and they disseminate it among members of their board. I'm going to call it board, public body. They all review it, they acknowledge it in a meeting, and then they decide how they're going to respond to it. Sometimes they can delegate the task of response to somebody else, or they can decide how to do it in the meeting itself. But they have 14 business days to respond to that complaint. It's usually about 20 straight days, including the weekends. If they do not have enough time because they're not meeting or they're busy, there's a bunch of reasons why. Good cause, essentially, is the basic rule we use. They can call our office and say, can we get an extension? And my boss, the director of the Division of Open Government, is a very nice lady and will work with the board to make sure that they have a good reason and that they can respond later than the law requires. So when they respond, who do they send it to? They send it to the complainant and they send it to our office. Sometimes they send it just to the complainant, and sometimes they send it just to our office. Neither of those is correct. You send it to both of us. At that point, the public body has responded in one of a couple of ways. Either they've said, no, we don't believe there's an open meeting law violation, and this is why. Or they say, yes, we believe you're right. By oversight and no intent, we did violate the open meeting law, and this is what we've done to correct it. Thank you for bringing it to our attention. Or third, somewhere in between. Now, surprisingly enough, sometimes complainants don't like the way public bodies respond when they say, no, we didn't violate the law, go away. When that happens, the complainant has the right to request of the Attorney General's office further review of their complaint. However, before they do that, they have to wait till 30 days after they initially filed it. And there's a bit of a time lag here, if I can see if I can draw your attention to it. The public body has 14 business days to respond, which is usually about, like I said, 19 to 20 days after they file it. But the complainant cannot request our office to review it again until 30 days after. And this is because the law is structured to promote as much as possible conciliation at the local level. And then, once there has been some sort of dialogue between the parties, to give the complainant some time to cool down before they decide to pursue the complaint further. This isn't about this is about compliance with the law. This is not about gotcha or anything like that. The goal of the Attorney General's office in all of these determinations and everything we're discussing now is education of the public as to how business should be conducted, and then ensuring that public bodies understand what their actions should be and ensuring that they'll go forward correctly within the bounds of the law. When they request of our office, they have to wait 30 days after they initially file it, but they can't wait forever. They have 90 days in total from when they allege the original violation, which is different from their time of filing, to file with our office. We will decline to review allegations which occurred more than 90 days before we saw it. So now that we have a proper complaint before us, what does our office do? We'll send a letter to both the complainant and the public body saying, yes, we've received a complaint, we're going to begin investigation on it. We will then begin our investigation, usually either through investigation letters or just phone calls, requesting materials and interviews so that we can understand the facts of what's happening. And during this whole process, we'll be asking ourselves, what is the requirements of the law? What occurred? Was this a violation? If there was a violation, was it intentional? Did the public body try to get around the open meeting law, or is this just a slip-up? There's a difference there. And then, even if there has been a violation or not, what did the public body do in response to this complaint? Did they take proper remedial action and try to fix it, or did they stonewall the complainant even though there was pretty clearly a violation? And so that affects our resolution, which comes in a variety of ways. We can do an informal letter or phone call, just sort of, all right, everybody's happy, let's just make this thing go away. We can do a formal determination, which is something that Jonathan and I spend about 60 to 70% of our time on, is investigating and writing determination letters which set out the facts of each case, the legal reasoning behind why we believe the law has or has not been violated, and then we'll issue a formal order at the end of those saying, don't do that again, or anywhere up to reinstate an employee, which is something I'll discuss in just a few moments. However, if we find that a public body has violated the open meeting law, that's not necessarily the end of it. The public body, when there has been a finding by the Attorney General's office that the open meeting law has been violated, has the right within 21 days of that order to appeal our decision to a judge of the Superior Court. But if we find that there has been no violation of the open meeting law, the complainant, the member of the public who brought the complaint originally, does not have a similar right of appeal. And that's because there's an alternative complaint process. So our office, or in this case, the complainant and 2 other registered voters, may bring a civil action in Superior Court to enforce the open meeting law. So they can either do an end run around our office entirely and just file right off the bat, or once we have issued a determination stating that we don't believe a violation has occurred, they may then file at that point, and that would be essentially their right of appeal. If you're filing suit against a state body, it must be in Boston at Suffolk Superior Court. If you're filing against any other body, local, regional, district, county, it must be in the county superior, in the county superior court of a county in which they meet. So if you are spanning a couple county lines, you actually get the option of all 3. Have fun. So what's going to happen if you violate the law? There's a whole range of procedures that we have. We can go from ordering immediate and future compliance. So this is essentially, yes, we realize you broke the law, don't do it again. We can make public bodies attend trainings like this one, which are just terrible experiences. We can compel the public release of minutes that have been wrongfully withheld. We can nullify any action taken in violation of the open meeting law. I mean, we actually have quite broad powers, because if the business of the public is done in a way that is not within the public's view according to the open meeting law, we can sort of set the clock back. And in fact, we can set it back so much we can reinstate employees that have been wrongfully terminated under the open meeting law, as well as imposing civil penalties of up to $1,000 if we find that the public body has done so intentionally or in knowing violation of the law. And then we have a wonderfully vague phrase at the end of our statute called other appropriate relief. And I'll leave your imaginations to that one. So, a quick review of what you've learned here this evening. If you are a public body and you are deliberating upon a matter of public business within your jurisdiction, and there is a quorum of you, that is a meeting. And when you have a meeting, you have to have notice for it. That notice must be put up 48 hours in advance of when you're going to talk about those things, except when there is an emergency. In the notice, you have to tell people where and when you're meeting and what you're going to be talking about. When you hold that meeting, the public must be able to attend it, except when you're doing it for an executive session for a confidential reason. But if you're going to do that, it has to be for one of the 10 purposes which I have previously identified to you. It cannot be for any other purpose, and you cannot let the discussion stray from those purposes. No matter whether you're meeting confidentially in a closed session or an open session, you must keep minutes the entire time. Those minutes must include a summary of the discussion which occurred, and must also include a list of documents and exhibits used at the meeting so that future generations will know how brilliantly you deliberated. When you become a member of a public body, you have to certify that you understand every word that I've said tonight. And finally, if, despite all of your wisdom, you still somehow manage to violate the open meeting law, I've explained that, that you will find about it first before anyone else does when the complainant files with the chair. Although they don't have to, sometimes they can go to a judge in Superior Court. So what are your resources if you don't understand everything tonight? You can go to our website. It's actually fantastic. When I was hired, I was surprised at how much information there was on it. mass.gov/AGO/open meeting. The law itself is codified at General Laws, Chapter 30A, Sections 18 to 25. It's fascinating stuff. It's not quite Shakespeare, but it's pretty close. The regulations are codified at 940 Code of Massachusetts Regulations, Section 29. We also have an open meeting law guide in case you don't like legalese. We have checklists. If you are a public body and you want to go to an executive session, you want to know how to keep minutes or post notice properly, we've actually provided checklists, which if you can go down and check off every box, chances are you are not violating the open meeting law because we've said so. FAQs, if you have a question, it's likely that someone else has had it before you. We've posted our most common questions on the website, so you don't have to call us right away. But call us anyways. We get calls all the time. And we have determination letters. As I mentioned earlier, all of us are aspiring artists, and sometimes we write for a living. And so what we do is we do the facts and legal reasoning behind every time we find a violation or not under the open meeting law. Jonathan himself is quite prolific. But if all of that is not enough for you, please write us a letter. We're at 1 Ashburton Place on top of Beacon Hill. Shoot us an email. It's the modern thing to do. Open meeting at state.ma.us. Give us a call at 617-963-2540, or again, visit our website. We even accept smoke signals under certain circumstances. Thank you so much this evening, and that is the end of the open meeting law presentation. And now, for those of you who don't want to rush off to the Bruins game, the index cards that we've collected, Jonathan will answer the first set, and I'm going to come to the room and collect index cards for the section that I did, and then I'll answer them after him. Thank you so much.
All right, so I'm going to go through and answer your questions, and we will be happy to stay as long as there are questions. And this is mostly from the first half. So if a member of the public attends a meeting and someone speaks, not in the designated time but allowed by the chair, must be recorded in the minutes. It's a little bit, this is one of those where the answer is it depends. The requirement for minutes is that there be a summary of the discussion of every topic. There's a summary of the discussion of every topic. So if the minutes include a summary that includes the information that person spoke about, that's fine. It doesn't necessarily have to be a transcript. It doesn't need to include what every person said. I think it's generally a good idea to record the comments of a member of the public in the minutes. But let's say you have a session where 10 people get up and say essentially the same thing, and you record in the summary of the minutes, 10 members of the public spoke and they said X. Do you have to say what each person individually said? Maybe not. That's probably sufficient. When during a public hearing, should public comments occur? And can the chair decide not have public comment during a public hearing? Public hearings are guided under different statute than the open meeting law. So there are different statutes that regulate public hearings. So it's hard for me to answer that question. We don't enforce the laws with respect to public hearings. So it's really going to depend on the public hearing, depend on that statute. My understanding is that generally public hearings are require the board to allow members of the public to address the board. But I would suggest following up with town council if you're a board member or a chair and want more information about how to conduct public hearings. Can board members discuss items they just deliberated on after the meeting is over? That sounds like a bad idea because remember, deliberation is any communication between or among a quorum on matters within the board's jurisdiction. So if they just talked about something in a meeting, it's within their jurisdiction, the meeting's over, you're now no longer in an open session, there shouldn't be any communication between or among a quorum on those matters. They can talk about the Bruins game tonight, they can talk about anything else that doesn't involve their capacity as members of the public body. What defines a subcommittee? A subcommittee includes any multiple member board that's created to advise or make recommendations to a public body. But it can be any subset of a public body where that subset, that multiple member group, has been given some authority by the committee. So if it's a 7-member committee and they say, we want these 3 members to review the budget, and we're going to ask them to go out and write a proposal and come back to us. Well, that's probably creating a subcommittee. That group now has to post notice. They're the budget subcommittee. The 3 members, 2 is a quorum. That's how it happens. Now, if 3 members decide on their own, or maybe 1 member calls up, if it's a 7-member committee and one calls 2 others, say, hey, I'd like to get together and talk about the budget, and they do that, and then they come back later to the committee and say, hey, the 3 of us talked and this is how we think. That's not a subcommittee. It was not created by the parent body and given some task or authority. But where there is some task or authority given to a subset, that is likely a subcommittee. It's a difficult question, and I encourage you to call us when you're unsure about whether something is or isn't a subcommittee, because that is one of our most frequently asked questions that we get. And it's going to depend a little bit on what happened. How did the parent body go about creating this group? And do people need to be appointed to a subcommittee for it to be official? Again, that's sort of that fact-specific question. It's going to depend how it was created. Do they have to be officially appointed and sworn in and all that? It may be a subcommittee even if they're not officially appointed, but if they're designated by the public body in some formal way, I think it's likely they are a subcommittee. Is the town clerk responsible for approving notices and approve that they meet the open meeting law notice standards? The answer is no. The town clerk is required to post the notice, but the town clerk is not required to determine its validity under the open meeting law. So I often get calls from town clerks who say, hey, this board just gave me this notice and I think it completely violates the open meeting law. What should I do? And I often will say, well, you should talk to the board and say, hey, I think there's a problem with your notice. And if the board chair says, I like the notice the way it is, then the chair should just post it, because ultimately it's the public body that's responsible for the violation, not the clerk. So the clerk's job is really just to post the notice. So don't depend on the clerk to approve it, or just because they post it, it doesn't mean it's valid. But certainly if the clerk says, hey, I think there's a problem with this notice, I would pay some attention. What is the definition of a spontaneous meeting, and is this legal? Well, a spontaneous meeting, I would say, is any meeting that's not noticed, unless it's an emergency meeting and it qualifies under an emergency. But if you're meeting and there's no notice 48 hours in advance, not including Saturdays, Sundays, and legal holidays, then it's probably not a legal meeting. If a quorum of a committee, so if there's 7 members and 4 happen to all see each other at the supermarket and they start talking about business within their jurisdiction, that may be spontaneous. It's also illegal. So it has to be a noticed meeting. And in the meeting notice, so this question sort of is asking about the extent of the description. So the example they provide is referring to a zoning bylaw. How specific does it have to be? That's a tough question to answer. I mean, I would say certainly if you identify the bylaw by title and a brief description, that's a good idea. But think of it again, what I always say is put yourself in the shoes of a member of the public. How much information would they need to have to be able to read that topic and really understand what it is the board's going to discuss? And do they have enough information to make a decision whether or not they want to attend that meeting? So I think most people can follow that standard and realize that's the level of detail required. Always err on the side of more detail. That really can't hurt. How soon must minutes be posted? Well, that's a good question, because minutes are not required to be posted. There's no requirement that minutes be posted physically or on a website. They just need to be made available upon request. For open session minutes, within 10 days, they need to be provided in 10 days of the request. For executive session minutes, it's within 10 days if the minutes have been determined to no longer be confidential. And if the review has not been undertaken, then it's within 30 days of the next meeting. The public body needs to undertake a review and make a decision whether the executive session purpose is ongoing or whether the executive session purpose is expired, and they can provide those minutes. Don't need to post them. However, it's a good idea. I really like to see when public bodies put their minutes up on the website for everybody to see. Strongly encourage it. I already had this question. What constitutes a subcommittee and what doesn't? And the example offered here was 2 or 3 members, less than a quorum, meet to review a chapter of the bylaw to bring back to the full committee. Do they need to post a meeting and take minutes? So again, that's really going to depend. If there's 2 or 3 members, so let's say it's a 7-member committee, 2 or 3 members, if they decide to meet on their own, that's a subquorum, it's not a subcommittee. But if during a meeting there's a vote or the chair appoints and says you 3 members are going to be the bylaw charter review committee, we are asking these 3 members to meet and bring us back a proposal, that's probably a subcommittee. What about social interactions in public settings and boards that may socialize with each other after a meeting? Again, social interactions are fine. There's no problem with a quorum being social and talking about things other than those matters within their jurisdiction. Anytime there's a deliberation, discussion between or among, any communication between or among a quorum, if it's on business, it's on matters of public business, and it involves a quorum, then that has to occur at a meeting. Any other social interactions are perfectly okay. What do we need to be aware of concerning social media, Facebook? Well, where do I start? Beyond the open meeting law, there's a lot. But in terms of social media, Facebook, it really is the same principles that apply. So if you're going to communicate between or among a quorum, whether it's on Facebook, whether it's on Twitter, whether it's on a website, whether it's on a blog, or whether it's in a room, the same rules apply. So if it's a communication between or among a quorum, it really has to happen at a meeting. So you should not have, for example, a closed Facebook group where a quorum of members are discussing business between a quorum, or even open, even on a website, because that has to happen in a physical meeting. You can't do it over email or over a website. So you want to be very careful about communications between or among a quorum. That being said, you as an individual certainly have free speech rights. You have the right to talk about anything that's on your mind. You can post anywhere. You can write a letter to the editor. But what we look at is, are you directing your communication to a quorum? Not to the world, but to a quorum. Must minutes be written, or can they be reworded? Or I think they're recorded, excuse me. So minutes do have to be in writing. A recording or video recording is not, they are not minutes. They have to be a written record. Site visits for a Board of Health, for example, with a quorum, must minutes be taken? Can you or can you not deliberate? So if a Board of Health or any board is going to go on a site visit, you have a couple options. If you want to deliberate at the site and there's a quorum, then you need to post notice. You have to have notice. You have to open it to the public and have a meeting. That can be very difficult for a site visit, particularly where you may not be handicap accessible. There's all kinds of problems. So one other option is you can have fewer than a quorum attend. You could have the quorum attend, but you cannot deliberate. So you got to think about the best approach there. A lot of public bodies, when they call me with this question, I tend to suggest the best way is to have one or maybe a couple members attend, come back, and then report to the board. Or do 2 site visits and have, or 3 and break up so there's not a quorum at any one. That's another way to do it if you want all of your members. And then they come back and discuss what they saw at a meeting. This is without question a very tough one, the way the law is written. I don't know that they got this exactly right in what they were trying to balance. But the law is pretty clear that you cannot deliberate unless you post notice and hold a meeting. Joint meetings, notice or not notice. For example, the Board of Health members attending an important planning board or zoning board meeting, can Board of Health members speak collectively or not if they didn't or did post meeting notice? So I talked about this a little earlier. If you're going to have 2 public bodies that want to both speak at the same time, at the same meeting, then they both need to post notice. There should be joint notice if one body is going to talk to the other. If the Board of Health members want to just sit in the audience and listen to the zoning board meeting, and maybe even get up and talk during public comment as individuals, they can do that without posting notice, so long as there's not communication between or among a quorum of those in the audience. Do all non-executive session meetings have to allow public comment or participation? So no, there's no requirement that an open meeting allow for any public comment. That's at the discretion of the chair. What if an agenda doesn't have a public comment item? And I think the question here is sort of, if there isn't public comment on the agenda, can you still allow it? It's always at the discretion of the chair. So even if it doesn't say public comment, chair can always allow public comment. It doesn't have to be in the notice. Some public bodies do put in their meeting notice a section for public comment or time to address the board. Sometimes they put, some public bodies will put a section in their notice that says topics not reasonably anticipated by the chair 48 hours in advance, which makes very clear that these are the topics that were not anticipated that are coming up and they weren't in the notice. That might include public comment or maybe selectmen comments or some other board member comments that weren't told to the chair in advance, and that's okay. What if an agenda item is sensitive private, for example, regarding a minor or a person with disabilities? Well, that's a tough one. If there's a proper executive session purpose that applies, then you might want to go into executive session to talk about that issue. Purpose 1 might be really where a lot of the sensitive matters come up. But if there really isn't an executive session purpose, again, if we're talking about public participation, because that seems to be what the rest of the card was about, it's at the discretion of the chair. If you're about whether or not you can talk about it, or you should, that's really a decision the public body needs to make. Public bodies are never required to go into executive session, but there are times where they may be in violation of other laws if they don't. Let's see. Is it okay for an agenda to just state new business where any committee member can bring up a topic previously undiscussed? And so, yeah, it's okay. And I prefer that language that I just recited to you, that maybe instead of new business, you might say topics not reasonably anticipated by the chair 48 hours in advance of the meeting, because that makes clear that when the notice was posted, these are the topics that were anticipated, and anything else that comes up was not an anticipated topic. And those are topics you can discuss. We do encourage, when it's a topic of great importance or great interest to the public, that the public body consider postponing discussion, or certainly a vote on that, to the next meeting so they can put it in the notice, but that's not required. It's up to the public body. This last card, I wasn't quite clear on what the question was, but I think it was the prerogative of the chair to set the agenda topics, and the chair does have that prerogative. The chair can decide what topics to list in the notice. That's putting the notice and putting the agenda together is the responsibility of the chair. That does create conflicts sometimes, and sometimes members want some topic on there that the chair doesn't put, and that may have to be handled at the meeting. Do you just have another question? And then similarly, I think there was about distribution of documents by the chair, who has the prerogative. Anybody can distribute a document to the board. Any board members, certainly third parties can send documents expressing their own opinion to board members. But board members can distribute documents to each other so long as they are documents to be discussed at a meeting. And they do not express an opinion of the board member when distributing the document. Again, it's here's a report. It can't be here's a report and I think we should vote to adopt it. It should be here's a report that I think we should discuss at the next meeting. So those are the questions I had. Mark's going to take some more, and then we'll stick around for any last minute ones.
All right. I can make this short and sweet for you. The first question I got is a video recording of a meeting considered to be an official record? Jonathan covered this, but no. Assuming that the question is, can the video recording suffice as the minutes? No, the minutes must be written. And the video recording itself is not a public document under the open meeting law, whether it is under the operation of other laws or by the fact that it's created by the town or public body is a separate distinction from our office. But in terms of how we deal with video recordings, they are in addition to, but not necessary under, the open meeting law. And they're also a great way of interacting with the public and displaying the public body's business. When using executive session purpose number 7, do you need to list the property add-on? Probably meant purpose number 6, which is the real estate exception. And there's also a couple other issues with the question. In terms of how much information you need to list when you're discussing the real estate exception, purpose number 6, it's as much information as you can so the public has enough information to determine whether the executive session purpose is proper or improper. But if you'll remember, the real estate exception is one of those where the chair has to declare that having that discussion in open session would have a detrimental effect on the negotiating position of the public body. And that extends to also how much information they state before they go into executive session. So if you're saying, you don't have to list, we're considering buying 900 Main Street, if nobody else knows that, because it might detrimentally affect your ability to offer a lower sales price. But if everyone already knows, that we're in negotiations on this particular piece of property, but we're getting down to the nuts and bolts, then you should probably list the address, or in this case, property add-on would only be appropriate if it was a public building or something similar. It would not be, purpose number 6 would not be appropriate to discuss a private party's piece of real estate which the town does not have a negotiating, or the public body does not have a negotiating position in. Executive session minutes. Who may record the minutes? Anyone may record minutes. Doesn't matter that you have someone set. It can change from meeting to meeting. As long as minutes are kept and approved, it's fine. You don't need to, whether you specify someone or not, the law doesn't require you to keep that person. There's no requirements from there as long as you have minutes. The mechanism of it is entirely up to the public body. What if a person who spoke at a meeting takes issue with a word recorded in the minutes? Do the minutes need to be changed, or does it matter? So that's really something that the public body creates its minutes and approves them. If a member of the public has an issue with it, of course, they have a variety of ways they can make a complaint, whether by voting or a direct appeal to the public body to change them. But in the end, the minutes of the public body, so long as they are an accurate reflection of what occurred, are the public bodies to take and approve. There's no control by the public so long as it's not an inaccurate representation. What if you don't have even unapproved minutes within 10 days of a request for minutes? So that's kind of a difficult situation. We understand that sometimes things aren't created within 10 days of the meeting beginning, which is what I'm assuming, that if you have a request for minutes the same day. Still, the law requires you to have something back in 10 days, hopefully minutes. If you need an extension or something like that, please feel free to give our office a call and we'll come up with a solution. Maybe it's some sort of mediation and discussion with the complainant, but technically speaking, once you get a request, the clock starts for 10 days to get those minutes to the person, whether they are.
You can say, if there are no minutes, you can respond by saying the minutes have not been created yet. So like if somebody on day one of the meeting says, I'd like your minutes, your next meeting's 2 weeks away, and you haven't created them in 10 days, then that's just your response. They can ask again once the minutes are created.
Yes, that's a better answer. And that's it for my questions. Do you have one verbal one?
How much, what's the amount that an employee can accept and not consider it a bribe? Because sometimes you do something special,
So the question is,
flowers or whatever, it used to be up to $50.
so the question you're asking is, how much may a public employee accept from a private party? That's governed by the state ethics law, and we're here to discuss the open meeting law. That's not under the same thing, so I would refer your question to the State Ethics Commission.
We don't enforce that.
That was gonna be my next comment here, because I know everybody does computer, and I'm wondering actually how much of the rules have been changed dramatically in maybe the last 10 or 15 years, but you used to give these hard copy. And this had all the rules very concise, and we used to give them to people when they came in to join a committee because they didn't know what to do. And all of this is very complex, and it's hard to digest as much as is in here. So this was a very simple thing to refer to.
Sure. If you wanted to, we have some materials we give out, nothing that small, but if you want to discuss further what we used to do, feel free to come up and discuss it with us further. If-
That's something that was issued by the Ethics Commission, which is not in the Attorney General's office, it's an independent agency, and so but I will say, in terms of your question about changes in law, the Ethics Reform Act of 2009 was a pretty big overhaul of the ethics law, of open meeting law, and also some public records, and as well as issues with bribes and with conflict of interest. So that's the last time there was a really big change. That took effect July 1st, 2010.
And I have one last comment. The AG does have the ability to not accept advanced postings, doesn't he?
I'm not quite sure I understand your question.
Because you said that people, that the committees can post meetings in advance. Depends on what the issue is. I mean, I had that experience with the elevator in the building here. And the AG is the one who had me do the research. And then, when they thought they could circumvent the system by posting a lot of meetings in advance, he wouldn't accept it. He said no.
If you want to come up and discuss that particularly with us later, it's probably not an appropriate subject for the entire. Sure. Fair enough.
But that was one of the
I still don't quite understand what the thing is, but we're more than willing to discuss it if you want to come up afterwards. But other than, if there are no further questions, we're all set. Yeah, sure.
Quorum is out socializing, not talking about public business. A member of the public approaches the quorum and asks a question about the public business. What happens?
So are you saying that there's a situation where it's like a social
So
situation?
social situation, we're talking about the Bruins game.
Yeah.
Unlikely but true. But
I think that's a tough balance between your duty as a public official to be responsive to a constituent and avoiding a deliberation. So I would say the best way to do that might be to ask some of the members to excuse themselves so there's not a quorum present, and then just have one person or maybe less than a quorum address that constituent's issue, and then if more people need to be involved, bring it up at the next meeting. That's probably the best way to balance that.
Well, thank you very much. Have a good evening.